Okay, people, today we have a pretty intense program. I'd like you to pay a lot of attention to the presentation we're going to hear now because Jorge is carrying out research into AI and has been doing so for quite a while. And he's going to be talking about the European Union's AI Act, which was adopted in March. He's living in Spain at the moment, although he's Argentine. Then we've got lots of other virtual presentations, and at the end of the day, we're going to have an in-person panel. We're going to be joined by Nicolas Antoniello and Rodrigo de la Parra, who's Mexican, but is also in Buenos Aires. So we're looking forward to that in-person panel. Jorge, are you with us? It's a little chilly here. I guess it's quite warm with you. Do you remember in 2008, it snowed in Buenos Aires? It is highly unusual. Adrian says hi. Hi, Adrian. How are you? So, I was telling the students with us that you're in Spain and you've been investigating the issue of AI for quite some time, and you're going to be telling us specifically about the latest EU regulation on the subject. I want to tell you that Jorge was the first person. I have to look at the primer at this point. It's like TV. Camera 1 or camera 2? Jorge was the first person to believe in our project several years ago. Well, remember we went to see him in Buenos Aires, and he had a very high post up in Microsoft, and we took him the idea. And as I told you the other day, at the beginning, it's quite difficult to launch an idea because you haven't got very much to show for it. Today, we've got lots of reports. We've, in fact, just been awarded a prize from the International Telecommunications Union. We were awarded the WISIS Prize for International Relations. So thank you to you and everybody who's believed in the project and our students. Jorge was one of the first people to believe in us. He said to me at the time, he said, it sounds great. I will support you. And he gave us the first contribution we received from a sponsor. So we're very grateful to him. And he's always joined us and contributed great content. So we're very grateful to him for his involvement and support. All right, so over to you. Hello, everybody. Hello to those of you in Argentina. I don't know what other countries are joining us. I am delighted to be connecting with so many colleagues today. And I'm also very grateful to be taking part in something that's attracted so much interest from my peers. It's quite complex subject, AI. So we're going to be talking today about the AI Act, which is what I've been invited to talk about today. Olga, thank you for the invitation. And I want to congratulate you for all the awards you've received. So today we're going to be talking for the next 40 minutes a little bit about the new EU Act on AI. It's actually got a very long, convoluted name which takes into account the different aspects of AI. It's a long regulation, it's quite complex. We'll be taking a look at some specific details later. It was adopted in the European Parliament and went to the European Council. For those of you who only understand... Hang on a minute, Jorge. We have simultaneous translation. I know that sometimes one gets carried away. If you could talk just a little bit more slowly. Okay, Olga, how long do I have exactly? There's an hour in total for your presentation. But the group is very interested by the topic, so you will be getting a lot of topics. We don't have a chat bot that's going to ask me questions. No, no, no. It's all the brick and mortar here. It's just ordinary people asking questions. Well, that's great. So we're talking about biological intelligence, are we? Well, we have a whole hour. We're going to be talking for 40 minutes, I think, so we have time for questions. I will try and speak more slowly. For those of you who do not understand EU law, which we call European Community Law, this is an act. It, we call it regulation in Europe, which was adopted at European level. And it's published, obviously, in the official journal, which is translated into all the official languages. And it's called a regulation. It's the act. What it does is apply directly to the member states. And it's important to understand this. It's not like a directive. The directives require to be transposed into national legislation. So why did this not happen with the regulation for data protection? The idea is that everything be as coherent and consistent as possible at a legal level, in the sense that these are within the competences delegated to the member states. So that's the first distinction. The second point is that the Act text has been approved, but it has not entered into force. And this, it means, has to be published in the official journal. That is probably going to happen the next few days. It's been quite a long journey, and what's happened is that the European Council what you need to understand is that they are co-legislators. It's not just the European Parliament that legislates, but also the Council of Ministers. The Parliament represents the people, the Council represents the powers of state. In the latest legislative act is that the Council has adopted the text at its session on the 21st of May. So it's all very new. As I said, we're going to go into its effects in greater detail. But the point is that this text, although it was adopted by the Parliament in February, has been adapted and amended and modified along the way. These are technical and legislative and linguistic modifications and amendments. If I use, for instance, there are terms that are used in the Spanish version. We've been there's been a need to correct some of the ways that the terms have been translated, for instance, into Spanish, which is something that I've been working on. So sometimes there are little distinctions or differences in the use of certain words. But the idea is to be as faithful as possible to the original text. I'd like to start, and this is when I give my class on artificial intelligence, with this image. If we were doing this in person, I'd be asking you, what do you see? What do you think of when you see this image? This is a tsunami, and that's what I call AI. Firstly, because it's a technological phenomenon, it's disruptive, which disrupts the status quo and which obviously affects legal structures as well and practices. We're having lots of conversations about AI, and all kinds of sectors are affected. When we say it's disruptive or it's a tsunami, we need to ask two questions. What are we facing? Secondly, how can we find solutions to some of the challenges that are also opportunities? So, what are we facing? A technological phenomenon which is disruptive, has legal implications and is totally revolutionary. And it's in continuous evolution. Even as I am explaining to you about this new regulation, the technology continues to evolve. But as it's a disruptive phenomenon, it's evolving in an unpredictable way. And this is very important in the general use technologies because we have to see how we can legislate this. We have some preliminary or partial solutions and some which are a little bit more complete. Now, what's the real point of disruption? The point is that we still don't know the effects that the problems that the disruption could bring further down the line. I always like to give you an introduction, which I think you probably had in one of the chats. So, how did we get here? This a new layer of innovation, which is built on technological advances and promises, which can be divided into three big groups. First, the extraordinary computing power, quantic computing, the power of processing on our cell phones. It was unthinkable only a few years ago. And that means that this computing power, which is now more accessible, such as cloud computing, for example, and it means that all of these data, which is the main input for AI, can be stored and processed using these powerful data analytical tools. The second contributing factor to the development of AI as we know it it's a little bit like, the science fiction stories of the 1940s and 1950s, or even the film about Alan Turing when he was trying to define the intelligence of machines as compared to humans. Today, the input from data analytics, which is underlying the the development of AI, is datafied. What does this mean? It's an arbitrary format that can be understood by my machines. And that's very important because this is the main problem by which the main problems cannot be fully understood because originally the data wasn't structured and the machines couldn't deal with this. The data is digitalized, it's in English, in the language that the computers can understand. And finally, we're looking at the analysis of data. So it means that we have tools and algorithms that are far more robust and can process this quantity of data. The information that has been datafied and digitalized in such a way to achieve the results that AI is delivering us today. So this is the second thing to be taken into account. Then the issue which takes us to talking about AI is that this is a new technological phenomenon which is disruptive and revolutionary, which is these are different aspects of data analysis which form the basis for AI, and this is part of any technological development, and this presents us with legal challenges which have to do with ethics or self-regulation. And we will see that the governance schemes being developed, which apply to any kind of disruptive technology, like internet was at the beginning, this is This was at the time a major challenge in terms of regulation and governance, and this is something that we were working on. To, now, these aren't all of the legal challenges, but if we have a look at them, we can see, first of all, civil liability, damages, and so forth that the model could inflict. And then there are other aspects that are involved in the value chain. This is a directive that is currently being drafted and hasn't yet been proposed because we haven't got everything regulated. We're looking at a cross-cutting regulation which is going to govern AI, but this doesn't mean to say that there aren't many more challenges down the line to be tackled individually. We're talking about intellectual industrial property, basic human rights, product safety, cyber safety, data protection. We talk more about fundamental rights rather than human rights in the EU. The GPRD, which is a Data Protection Act, is virtually become obsolete with this latest regulation. There are a lot of connections between the personal protection data and what is being legislated about AI. So this presents us with a whole new raft of challenges. So this is a pending issue for legal authorities, for the jurists, and also for the European Union bodies. Now, how this interrelates with other legal regimes which have to do with digital law. This doesn't necessarily help us to govern AI because it's new, but it does have to do with the personal data protection. And just to mention a couple of things, we have the law which regulates digital data, data governance, Data Act, the Data Market Act. It's like a legal pyramid which is being built. And we still have a lot of tasks pending to interrelate all of these and how we can make all these different laws support each other. So in the recent Council of Ministers meeting, they requested a plan for the Commission to start studying all of these different laws to ensure consistency, the rule of law, and coherence in the application of the regulations. We could go on identifying different challenges to which there are as yet no answers. The issue of discrimination carried out by algorithms, which is all sort of covered by the Data Protection Act, but we also see that it's being embedded into this new regulation. The long road ahead of us to regulate AI in a holistic and cross-sectoral way is still ahead of us. Why do we talk about governance? All, all roads lead to governance in Europe because AI is a global phenomenon. It's disruptive, as we said, and it's in this fragmented world in which we live. National law can always provide a complete answer. So we have to look at this from the different points of view, including national laws. What has the EU found as an answer? What it's talking about is extraterritorial effects, and this depends on where each different AI system has been evolved, and to analyze the different points of contact it has with things at European level, which is dealt with in Article 2 of the regulation, and to see how the European norms can be applied independently of where these systems originate or their main markets within the value chain. Why should we talk about ethics? Well, ethics is a pillar of law, and it has to be binding. Ethics are important, but we cannot leave it in the hands of the private sector because there's a conflict of interests. Independently of the best intentions and efforts that the private sector is making, like Google and an Alphabet, to have these independent and impartial ethics committees, that's not advanced. That's not enough, because we really do need to do is define binding ethics laws which oblige these companies to adhere to the rules. The main principles, recommendations, and guidelines included in this act are the most recent ones, and they include OECD principles, which gave rise to this new act on AI. In one of the preambles. And this defines ethics from an X point of view and refers the subject to the experts which have been designated to deal with this matter. However, these ethical principles, even as they are being analyzed by these experts, at the moment, it's been only suggested that they form part of the self-regulation aspects, along with guidelines about behavior. But they haven't been included in more binding legislation. So what's the problem here? The problem is the parts that aren't binding, because there is no universal control over what different countries can do or sell when it comes to programming AI and using the data. So everybody can interpret ethics as they wish, like Professor Mantelero, for instance, who's one of the pioneers in studying the revolution of AI and its impact on on the area of fundamental rights. He's written a number of documents, which we call the soft log, about recommendations, principles, and guidelines about ethics in the field of AI. Ethics, which has been applied to many years, for many years to the main companies active in the technological arena. Self-regulation continues to be important. There's a whole chapter dedicated to good practices. In this case, with a certain intervention from the authorities making up the governance of AI, which means that everything has to be approved by the European Commission, and something in which I believe are the standards. It's very important that we start to develop standards which are universally accepted, not only by the European bodies, but at a global level, which can help to self-regulate certain aspects of the application of AI. One of the standards is also about regulating two key aspects: health, for instance, where fundamental rights may be at risk, police surveillance, biometrics, segmented marketing campaigns, for instance. So that's a sector that will be affected. That will be affected by the regulations. We need to have some kind of surveillance aspects and standards in place. And I think that in that sense, the regulation is doing the right thing. Now, when it seems that ethics is not binding, perhaps it's too strong or the interpretation is not a universal one, then we have a situation like the one we've been talking about, where there's uncertainty and ambiguity. It is certainly true that the industry has failed to self-regulate adequately. It had all the right intentions to self-regulate, but at one point, The financial crisis of 2008 showed us that we shouldn't leave everything in the hands of the private sector, in that case the banks, and that it was necessary to intervene and introduce ethical standards. And this is a bit similar. What is the regulatory context? This is something that's very interesting. Some time has passed since 2018 when the paper about efficient governance in the era of AI was written, and this has an influence on the development of the current regulation. Firstly, we have to talk about people's interest in doing so. If you look at public policy codex, you can see all the list of initiatives that have been taken or adopted in the area of AI. Now, there is the factor of fear of the unknown because people don't really understand what AI is. There are different interpretations of this. And there are some questions which have to do with the utopian and dystopian aspects of this. And the most worrying issue, and what we're going to be regulating specifically, I always mention that when Zuckerberg had to testify before the US Senate, the questions showed that there was total lack of knowledge of how social networks work. And this is that we're facing a similar situation. Now, the third point, within this paradox, we're looking at the opportunities of AI, which are pretty clear, which the regulation doesn't covers in a specific chapter on measures on innovation, and then it talks about the challenges which have been identified to date. And when I talk about a paradox, it's because the EU took a long time to understand that it has a single digital market with 400 or 500 people where the social and economic opportunities presented by data analytics can be materialized. This means that it needs to take a number of measures which are reasonable and allow people to use and reuse the data within certain limits. And this is something that the EU has tried to establish in this act. We're talking about different areas in the area of health and safety, democracy, and so forth. Now, the issue is that all of this is in the context of geopolitics. The regulations and the different documents that European Commission handles have to be approved by all the member states. So this is a geopolitical issue. It's a competition. Obviously, there is competitiveness involved against principally the United States, which has so far been exploiting European data until we began to understand a little bit more about what the business implications were. So certain measures have been adopted then, and now it's developing an AI measure. We could talk about Chile or Russia or other countries that are working in this area. So there is a certain degree of competitiveness in the world. A Spanish legislator said to me that some of the dispositions in Biden's law on AI had been adopted into the EU's regulation on AI. Biden's law is far more limited in terms of the application of the laws, and it applies to federal agencies, and it's more about cybersecurity. But there is certain regulatory competences. Then there are other different poles at international level, like India or Russia, and in a world which is completely fragmented, where internet, which was born in a slightly romantic and naive way. And now we're talking about sovereignty of data, information sovereignty, and new barriers are going up where we may fall into the trap of national rights. So we always need to talk about global governance rather than national governance. And then the questions are obviously what should be regulated, what shouldn't be regulated, what kind of models should be applied, and so on and so forth. Now, talking about regulation per se, which is one of the pillars of this global governance, we'll look at some of the background to the AI Act. Here is a list of some of the key documents. I don't know how many pages, but basically there's a series of proceeding acts, parliamentary resolutions, commission decisions, the ethical principles that I already mentioned, a European Parliament resolution from 2017, which talked a lot about robotics, and that's kind of got faded away a little bit. But it was one of the first documents which tried to answer the issue of AI with regard to robotics. So they were talking about giving it legal personage to the developers of AI systems. Two key documents. The regulation presented by the European Commission in 2021 in April, which has taken 3 years to go through the process with an approved text by the Parliament and the Council, and the ethical principles, which I mentioned earlier. So these are the basic documents. The EU has lots of sites for those of you who are interested to carry out further investigation. In fact, the European Parliament has a parliamentary information office where there are a series of briefings and papers which are what the legislators read. So it's very important for you to know that it's not just for the lawyers, because we have to look at the way these legal documents are interpreted. And it's very important to ensure that the legislators are fully informed as possible. So go and check out those briefings and read the preambles, because in some aspects, which, and also in the annexes, there is a lot of content which is interesting to read. But you need to read the preambles to see what the interpretation of the legislative aspects are. Finally, as I said, on the 21st of March 2021, sorry, this is the earlier document. I can see it's but what I'm talking about is the May approved adoption of the document, of this final version of the text. This is so you can see the entire legislative process. It's quite interesting. If you remember, I said it's been going on since April 2021 till May 2024. It's a process that took 3 years, discussions, negotiations, amendments, etc., involving all the institutions at their respective points. It was approved at a first reading within the Parliament, which means that there were no further observations from the different commissions. It was adopted by a majority on the 13th of March 2024, and then on the 21st of May, the final text was adopted. It's not yet binding. As I said, it hasn't yet been published in the official journal. Now, if you look at the text, it's important to understand the parliamentary process and the background to these negotiations, which ended up with these trilogue meetings, which is when tripartite meetings when the European Commission, Council and Parliament sit down together. And now in December, this happened under the Belgian presidency in December, and in January, the text was once again adapted and amended to approach what would be its final form. Now, this is simply just to give you an idea about the background. This enables you to understand that the AI models being treated have reached a state of consensus. That means that different groups had to make concessions to come to a consensus. There was major lobby on the part of the private sector as well as the member states. France, Germany, and Italy was a bloc, was generally more pro-industry and liberal. And this is because France is very keen to open it up to unicorns. That the European Parliament's position is a little bit more centre, and was more preoccupied about fundamental rights. This means that general use AI models, which in this sense, the text isn't yet complete and has delegated to the Commission and the AI office, which will be the organ which will be in charge of supervising all the aspects related to general use of AI. The AI office, which has been set up, I think yesterday, the structure it will have and its tasks was approved yesterday, and it will be involved in all aspects to do with AI. The Commission has delegated its powers in this AI office. Right. Yes, we have we have an AI law or an act. I've been writing about this. And obviously I'm being very involved in the text itself and how it could be translated into Spanish to come up with the final text. And obviously I was very involved in all of the investigation that led to this final result. This is the general structure. Then at the end, I'll show you. I can give you a copy of the presentation, but this is a bit dense, as you can see, so you can read it at your leisure afterwards. But I want to make sure that everything is covered in my presentation. As you can see, it's a long and complex text. It's quite convoluted as well. It's lots of references to other measures, references to the annexes, and interrelations with other applicable measures in the European Union. 113 articles, 180 preambles, 13 annexes. It's about 450 pages. This table of contents, which I will leave you as in the presentation, has an interactive index, so you can go immediately to the sections using the hyperlink. And something else which I think is a fantastic when it comes to AI and its different uses, because in the slide you'll see an application which is a chatbot which answers FAQs about AI and the application of the measure. And I think it's a good addition to the measure. I think, however, it's always important to go back to the source and check for yourself. The scope of application, I'm going to speed through this a little bit. We've talked about extraterritorial aspects, and one thing that is important to underscore is that this is not a law of horizontal or cross-sectional application as regards each citizen residing in the European Union, but it defines key players in the value chain of the development and deployment of AI applications. and specifies different responsibilities. For instance, if you are a person that is affected, you can identify that in the slide and you see the regulation that affects the rights pertaining to that person. For instance, if I'm a supplier, and this is where the largest number of obligations fall upon suppliers. They are identified with a specific role within the value chain, and the responsibilities of the deployment of AI are also defined, as are its applications. And there is what is a down the line, downstream supplier, which means that they have another role to play in the value chain. And then we have other kinds of suppliers, manufacturers, and other players. Each player is defined and has a specific role to play within the value chain, and that's important because the designation of responsibilities and rights and obligations is specified in the value chain, which includes production and distribution. One thing that we're going to be talking about later is that these are open source and free license systems, as and when there are no systemic issues and there is no interaction directly with natural persons, with individuals, or the use of personal profiles, which are always labeled high-risk AI system and can be a problem in the longer term. Now, first, this is possibly basic at this point. We do need to establish what AI is. A lot of people have been writing about AI and trying to come up with a universal definition applicable in the regulation. This is what it is. It's very important to see that not all AI systems are involved, like Excel sheets, for instance. An Excel sheet isn't an AI system because it can't be adapted, it can't learn, it can't develop new inferences using the data. Now, if that Excel spreadsheet, on the other hand, is part of a larger model where it's embedded into a more comprehensive system where, for instance, there's a chatbot involved, the chatbot can transform text or images into a voice even. So that's where we're using AI. But we need to be careful to define exactly what AI is and refer to this definition, which was adopted by the OECD. And although the regulation refers to the OECD in its preambles and provides an explanation of this as of its definitions. Let's look at the general model. You need to understand what the obligations are in the value chain. It's like ChatGPT, for instance. ChatGPT can sometimes put things in images too. And there you can see the different persons or subjects involved. And it's important to see the responsibilities and obligations of each one. What's particularly important about the value chain is to see something that it's been quite well done by the legislators. The observations are not always the same, and the AI models of general use may be open and can be free at certain levels, and the codes can be modified. And these are tiny things that we need to understand so we can see how it applies to different sectors. Now, the regulation also talks about the life cycle of AI applications. It's quite long, it's iterative, and has to do with different stages or phases from the concept when you sit down with a developer until its deployment and implementation. There are lots of intermediate stages which one needs to understand, such as the subsite for data processing, which has to do with the, the development stage, and the deployment layer. We're not going to go into this at this point, but we need to talk about the value chain, the life cycle, application of AI, and we need to talk about the data processing cycle, because these are different ages. So here are the responsibilities. The important thing is that you need to check out Article 20 if you have any questions, where all of the obligations are described in detail. And you can see that most of them are incumbent upon the supplier. Moving on. This is fantastic. I didn't do this. You can see the credits at the top, but I think it's great in terms of legal engineering, a flowchart that shows us each of the successive aspects and what legislation or regime covers them, depending on what kind of player I am and whether the application answers to the objective sought. So I thought it was very interesting to show you this. It's not the main subject of my conversation, but I wanted to show you how we are working on the legal engineering side of things, or the legal design side of things. The pyramid represents the main focus of the regulation, which is risk-based. The European Union, part of the issue has to do with risk and safety. If you look at Annex, it gives you all the harmonizing regulations by sector and specific use. It has a specific treatment given to AI systems which are associated to those measures and have to do with product safety, for instance. So this pyramid, which in our original proposal drawn up by the European Commission, did not have the top bit, which have to do with systematic risks of AI models of general use. I think it's pretty graphic and reflects risk levels on whether these are acceptable or unacceptable. Then there's high risk, which is governed by specific aspects. So here we're combining the stratification by player in the value chain and also by the kind of use according to the specific sector and the risk assigned by the regulation to that sector or specific use of AI systems. Also, a very important thing about this pyramid is that, like with any pyramid, we have the basic, which is the broadest sectors, but also the order in which it is. As you can see, the yellow is systemic risk. The high risk is very, very tall, and there is a reason for this because it defines a number of systems that fall into each of these categories. Well, prohibited uses, biometric data, use of biometric data. Finally, this is how the text looks. It has to do with social scoring. This is a little bit to distinguish ourselves from other countries which are perhaps more permissive in this aspect. Police surveillance, predictive police surveillance, all those sorts of applications are highly regulated. It's prohibited, in fact, recognition of emotions using some kind of biometric aspects, and anything that has to do with using surveillance camera footage or images. So this is the red part of the pyramid, the top bit, the unacceptable risk bit. Then this is the second level, which are high risk systems, which is the fattest part of the pyramid. And these are covered in Annex 3. So again, it's sector and use specific. We have biometric systems, critical infrastructure, education and personal information, essential services, all the different sectors, and that are described as high risk. Now, they're identified more specifically in Annex 3. Now, we have to see exactly what the use is for it to be high risk. There has to be a degree of harm involved to fundamental rights such as health, safety, fundamental rights, etc. I may have an application of use in the health sector, and if I ask, the supplier must be able to prove that this does not lead to harm to people's health or their fundamental rights. So we have to combine the sector and the specific use with significant harm to fundamental rights and the other legal aspects which govern that side of things. There are a series of general obligations. It's important to understand this, particularly in the context of high risk, which has to do with risk management and refers back to data governance. It has also to do with the way that systems are trained, the technical documentation that the supplier needs to have, and apart from the security obligations that the supplier has, is the evaluation of impact on fundamental rights. Another issue is the supervision, the surveillance of natural persons and those responsible for deploying the data and the system. There are certain features that have to do with the data, and we have to make sure that everything is properly protected in terms of cybersecurity. This is a synopsis of how we are working with the high-risk AI. General use AI models. This is a line of research and development which has been underway for quite some time. It means that AI is developed and trained for specific uses, particularly for practical application. In 2022, this led within the Parliament to the development of this particular sector. There was a lot of lobby from companies and from certain member states, France, Germany, and Italy. In this aspect, I think that the evaluation here is only partial. It's incomplete. And there is a general principle which associates computing capacity with the capacity to cause harm. It means that basically that there's a score given to things which evaluates the impact, and that in turn defines risk. There are lots of definitions about how the indicators are used to evaluate impact capacity and the capacity to inflict harm, which is a legal interpretation. And this is the area where different legislators can recognize this and delegates a lot of powers to the Commission's AI office so that they can start to correct the indicators being used. There's a lot of detail in the annexes, particularly 11, 12, and 13 of the regulation. To summarize, is a series of obligations which are horizontal, independently of the risk involved, which have to do with transparency, interaction between people, biotext and image, so that everybody knows clearly who they are interacting with, the emotion recognition systems, and everything that has to do with deep fake. There is also a series of measures that have to be taken in the context of deployment to avoid deceiving the end users or misleading them about the content of these services. So everything must be very clear, must be distinguishable, so that anybody who is interacting knows that they are dealing with an AI agent. Governance, and with this I will wind up. These are a number of different organizations involved. European Commission, which has lots of powers delegated in it and is managing some critical pieces, particularly the annexes, which have got a lot of technical content, particularly general use models. Then we have the European Committee, which has the powers to delegate and has a number of representatives from each member state, which is also involved in the data protection, personal data protection commission. And they're also very much involved in governance. Then the advisory committee, which is once again representative of different interest groups. It's multidisciplinary, and I think it's a major contributor to the regulation, and a new figure which has been regulated, which is an independent scientific body, which will be the repository of knowledge on AI for general use. And this group is made up of different disciplines, but mostly from data science. Now, they can issue alerts. Now, what I was saying earlier about the unknown effects of AI for general use, well, this group of experts can issue alerts to the Commission, and the Commission can adopt and determine that certain applications have a systemic risk and regulate them accordingly. National competent bodies, which includes market surveillance authorities, and these are national authorities or national bodies, legal bodies, and also European legal bodies who are in charge of applying the regulation and enforcing it and ensuring compliance. So these bodies are going to be in charge of authorizing and ensuring that the regulation is complied with. And then finally, we have the notifying bodies, and they're involved in different security policies according to the regulations or national legislation in each member state. These are other important bodies involved, such as the European Commission, which will approve the code of conduct, the interpretive guidelines, approval of standards, imposing sanctions, and what they call delegated acts. This is a power that has to do with, for instance, to define systemic risk. It says that, for instance, the Commission can develop further standards to regulate specific criteria. So it's a work in progress. So once again, when you have a look at the text, you can see the articles, the annex, and the preambles, and specifically which are the different guidelines that the European Commission is in charge of applying. And then, as I said, the AI office, which was created very recently, and the structure was just set up yesterday or the day before that, has a lot of powers, and basically it's going to be the institution in charge of monitoring the application of the regulation about AI for general use. We have sanctions. There is a general principle which has to do with the company, its circumstances, effectiveness. This is a work in progress. Again, it's evolving, and as you can see, as regards startups, will be obviously the fines will be lower, so it's proportional. This slide is something that you need to study. It still hasn't been published in the official journal, so it will not be effective until 20 days after its publication. And then there is an adaptation period of 24 months. These terms may end up, this time schedule may be less, particularly when it comes to high-risk AI, and that has an application period of 36 months. In each case, there is a different time schedule given to each system, so I can understand how effective when it comes into application for each system. To wind up, I want to talk about opportunities and challenges. I haven't talked very much about opportunities so far, because this is really a moment of great innovation. We've carried out tests in sandbox situations, but we've also carried out tests in real conditions, which is very favorable for the industry, particularly when it comes to the different applications. Not only because we need to test it, and it's very interactive, and we understand that people have to train systems and eliminate biases and carry out tests in the early phases, but because thanks to trial and error, as you know, this is how you detect mistakes and can correct them. You can correct the algorithms and things like that. So controlled environments in sandbox situations, and also real-life situations where they have to carry out a number of tests which have to be approved by the European Commission. As you can see, this text is quite ambitious because it's extraterritorial and because the European Union wants there to be a standard for the development and deployment of AI applications around the world, which goes a step further than the Data Protection Act. This is what's known as the Brussels effect. It's complex, it's very dense, it's very convoluted. You have to browse through the different parts of the regulation. we have to refer back to the definitions in Article 3, including the definition of AI itself, because it specifies what's covered and what isn't, and it's pretty unequivocal. And finally, you need to know this text is a result of consensus and compromise. It was a complex debate under a lot of pressure, particularly when it came to definitions. And then you have to look at the way that how it interacts with other measures and what we're calling the codification, the digital codification of AI. We need to ensure an efficient rollout of implementation throughout the different institutions involved, including the governance of these tasks, and we need to know how the authorities, the member states, are going to work with the European Union bodies to ensure that this is uniformly applied, to see how the codes of conduct are going to evolve. There's a lot of work to be done by all these different players, and how it depends very much on how they work together in the aspect of governance. But this is the first horizontal standalone law. Everything is a learning curve. As you know, we carry this out, and the different parts of this legislation that are still pending, that we talked about earlier, such as the legal challenges, are worked on, particularly the legislation on digital matters. As that evolves, we will continue to sort out and iron out the problems. We always have to take into account fundamental freedoms and rights, and bear in mind intellectual property rights, corporate rights, and other legal rights which are currently being discussed, as we need to find ways of solving this. All of the tests that are being carried out in sandboxes will be incredibly important when it comes to understanding what's needed to create a public repository of information about AI. Trial and error is fundamental. The model is obviously needs to be improved. I think that it's important to focus on the risk and make sure that the legislation applies specifically to the life cycle aspects. It's got to be as tangible as possible, because we need to ensure that we have the CE brand or copyright. It's quite difficult to apply to softwares and systems because it's intangible, but in fact, that's not quite the case. There is a value chain involved, and it must be branded and approved to show that it complies with the law. Here we have the exceptions. It's still a little ambiguous, it's still a little vague. But we've got the offices, the standards, the code of conduct, and obviously the role played by justice. When we're talking about data protection, we're also talking about different aspects that have to be dealt with, because this is part of the many challenges that the disruption brought by these new technologies brings. So here we are. I hope that you've understood a little bit about the evolution of this new technology, which is growing so quickly and moving so fast. And the idea is, what we want to do is respond to a reality which is constantly one step ahead of us. The idea is that we try as hard as we can to resolve this by using all the methods at our disposal, not just analog but digital, and even employing AI to help us. Here are some resources that could be of interest for you if you want to continue your research. And of course, there's my contact data too, so you can contact me. Okay. Right, these are my contact details. And a round of applause for Jorge. So I hope I've been able to shed some light on an issue which has been so complex. There are not as yet many people talking about the regulation. We're still digesting it. It's a very dense issue, and there's still many issues that are yet to be resolved. Right, a round of applause for Jorge. Thank you. We have lots of hands up, keen to ask questions, but we don't have very much time. So I'll just take two or three questions together. I love the level of detail you include in your presentation. And I think it would be great if you could share the PDF with us because we would be able to spend more time on it. Let's take three questions. We have Luis Miguel online already waiting for us. We're not talking about Luis Miguel the singer. No, Luis Miguel Martinez has the same name. He's a friend of ours from Mexico who is patiently waiting to come online. Hi, Jorge, how are you? I'm Ana Lucia from Peru. I have this question. What is the limit of the state of governance? Because you were saying that self-regulation is very, very important. So, what are things perhaps a little tougher than we've been led to believe? Hi, Jorge. Thank you for the presentation. It was a bit overwhelming, really. It's a lot of information, and we'd be very grateful to be able to see your presentation and digest it with more at more leisure. I'm Rosa Yelen. I'm an expert in IT project management, and what you were talking about the life cycle and how each of the stages has been regulated. I'd like to know a little bit more about the process and how you identified each point to be tackled. And as this is a global regulation, I'd be very keen to know what chances there are of being able to play a role in this regulation from these latitudes. One more over here. Oh, there's so many hands up. You just need to send Jorge a mail, okay? Oh, yes, absolutely. I love talking to students, so please send all the questions that you'd like to send. One more question. Hi, Jorge. I'm Victor from Brazil. Yesterday, we had a presentation about AI from Patrick from the European Council. Patrick Penny from the European Council. He said that that in geopolitical terms, Europe is not a producer of AI, but more a regulator of the industry. China and the US produce the technologies, and Europe regulates them. That was just a general appreciation. So, what do you think of this global reality? What influence did it have on the development of the AI Act? Over to you, Jorge. I'll try and answer as best I can. The limits of governance is a very good question. Has to be a local limit, obviously. Each country has to establish this according to its own legislation, its laws, its values, its culture, its rights. And then industry has to do its part. They need to go into the nitty-gritty of the regulation. We have set the principles, and now we need to allow an organ, which could be a regulatory or a surveillance organ, to get into the nitty-gritty of the fine print, to look at different aspects of the application of the principles. Now, the objective of the regulation is to limit the risks and protect the rule of law and democracy, but it also wants to encourage innovation. So perhaps we need to balance this a little bit better. Particularly, we need to involve citizenry. We need to involve civil society in the AI committee and also the independent experts committee. Why am I saying this? Because sometimes people only interpret what citizens want, and these ends up creating monsters. And the idea is to offset that possibility. So the European Union basically is at this crossroads at the moment. It's realized that it has a legal framework in place. It can foster a data based economy, but it needs to be more inclusive. It needs to strengthen the rule of law. And I think so far we only have two unicorns, Mistral, which is in France, and one in Italy. So the results there are going to be a bit limited. Now, what I was saying earlier is that the European Commission constantly evaluates or assesses the efficacy of what it's doing. And of course, there will be changes along the way, but at least there's an opportunity to start regulating AI through this legislation, and then we'll see whether it's actually being met and complied with. And there's an awful lot to be done yet on this roadmap. For instance, the digital codification. Now, regarding the different stages, I think Eric asked that question. The life cycle. The issue was mostly the AI for general use because people understood that there was a general training involved and that we had to differentiate between these phases and include trial and error. And particularly when it came to regulating the quality and the quantity of data involved, as well as data governance and data management. Perhaps deployment was more of an issue in the later stages, rather more than codes. There is only one sole implementing body, but there may be many more involved downstream as we move ahead. So perhaps what was happening was that we at different stages we didn't necessarily know who the main players were, so it took time to identify them. And this all contributed to the legislation on AI for general use. It's as yet preliminary. It's a compromise text. A lot of powers have been delegated, but that's where we are. Another round of applause for Jorge.
Many questions are pending. However, they will be made over email. And please send us the copy of the PowerPoint. I will use it in class and I'll borrow some ideas from you and take advantage of your generosity with all this know. Thank you very much. You read this from here from students, from Adrian, Oscar, Jaime, and the whole team. Local, international students, people that are online. I hope to see you in some place, somewhere else, probably in Europe. Thank you. Thank you, Oscar, Adrian, and Olga. It's great to be here, and hopefully, this avatar does not become a metaverse. Thank you. Thank you. Goodbye. Yeah, I'm going to see later the presentation. There's a wealth of information that I would like to study that and then share it with you.